Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Good morning. Thank you for joining the show today. Today, our topic is how bankruptcy impacts the sale of real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. You can follow us on Facebook. You can also follow us on YouTube. Go to YouTube, click the subscribe, click the like, follow us. That helps us provide you more and better content. With that, we're going to go to Sean, who has our legal update.
Yeah. For our legal update today, I want to talk about a small estate affidavit, or some states call it an affidavit of heirship. We also call it here in Arizona as an affidavit of succession to real property, which in Arizona is a probate. It's just not an administered probate by the court. But in order for you to convey property by affidavit, you actually have to file the affidavit first with the probate court, and then the probate registrar reviews it, makes sure that everything's in order, and then they approve it. And then once it's approved, you take the certified copy of the affidavit and record it, and it's the affidavit that actually conveys title of the property to the heirs. So it's basically a streamlined way of moving real estate from the decedent's name directly to the heirs. So there's no personal representative, there's no executor that needs to sign anything. It simply goes from the decedent to the heirs.
There's not even a deed.
Not even a deed. The affidavit is essentially the deed. I mean, it's the document that conveys title to the property. Now, to qualify for the affidavit, or to convey property by affidavit, there's a few things that have to be in place. Number one, the total equity value of the property. So it's not the actual value itself, but it's the total equity value based upon the Maricopa count. Well, I say Maricopa, based upon the county assessor's valuation as of the year of death, has to be less than $100,000.
So when you say the county assessed value, I don't have to go get an appraiser.
Correct.
To tell me how much my property's worth.
Correct. So if you go onto the assessor's website, whether it's Maricopa, Pinal County, Pima County, La Paz County, you go onto the assessor's website, you plug in the address, they're going to give you an assessed value of the property. Normally they give you a historical assessed values as well. So you can go and figure out what was assessed in 2016 and 17 and 18 and on forward. You can figure that out. So it's the assessed value as of the year of death minus any liens, claims, or encumbrances. So, if the property has an assessed value of $280,000 and it has a $200,000 loan against it, that is a property that you could do an affidavit of succession on, because there's only $80,000 in equity. The other requirement is you have to wait 6 months from the date of death. So if the owner passes away, you can't do anything for 6 months. And the theory behind that, or the reason why the statute provides that, is they figure, well, that gives an opportunity for creditors, for other interested parties to come out of the woodwork, for a probate to be open. All of that should occur or can occur within that 6-month period. So it's kind of a waiting period to figure out if anything else is going to happen that would impact the ability to do an affidavit of succession. And then the third thing, there's a few other requirements, but the main other requirement, the third requirement, is that there's no probate open, whether here or in Arizona or any other state. So there can't be a probate. If there's a probate open, then that then becomes the property becomes property of the estate under the exclusive charge and jurisdiction of the personal representative or executor of that estate. They then have the right to control that property, and you can't do an affidavit of succession in that instance. So your three main requirements are, the assessed equity, the equity value based upon the assessed value is 100,000 or less, that there's no probate open, and that the owner has been deceased for at least 6 months.
Now, where I have seen a mistake on this, that's not the only type of small estate affidavit.
Correct.
There's others that have different requirements. Mainly, when we talk about property, we're talking about real property and personal property, basically. Why don't you explain the difference and how some people sometimes might mistake one for the other in terms of timeframes, because there's different requirements, right?
Yeah. So for the personal property, you don't have the 6-month time frame. That can be moved by affidavit. Basically, you have to wait 30 days, and then that one can be moved by affidavit. And that the small estate affidavit for personal property does not require court approval. So you don't have to go to probate court. So if you have $30,000 in a bank account, then you can use the small estate affidavit for that purpose.
Okay. Very interesting. Well, so it's got its costs and benefits, doesn't it? A benefit being you can move property potentially without the filing of a probate and going through the probate process. Disadvantage, you're waiting 6 months.
Yeah. And the other disadvantage, and what a lot of people don't think about now, if the property doesn't have tons of value, maybe there's not a lot of exposure. But the one thing that I don't like about it, and if I were an heir, I may not like, is it actually puts me on title to the property as an heir versus, which means that, if there's a later lawsuit for lack of disclosure, well, I'm the seller. If I'm going to sell this property, then I'm the seller. I'm the one signing the purchase contract. And therefore I have all the duties of a seller under a purchase contract versus if, it's being sold by the personal representative from the estate, well, then it's just the estate that's on the hook. It's not my personal assets. As a beneficiary of the estate, I'm not pledging my personal assets for the performance of the personal representative of the estate. So that's another downside, is you're actually putting the heirs on the property, and you're waiting 6 months too.
Yeah, and it assumes too, when you say that there not be a probate filed, that typically also means that there's not unsecured debt out there that a probate would have otherwise wound down or determined that there isn't any. And you can see those circumstances where you get it conveyed, new beneficiaries are put on title, and all of a sudden the credit card statement that slipped under the desk and the fan blew behind the curtains or whatever, they finally realize, and that was never resolved in any sort of probate.
Yeah, that's correct. Now, you're supposed to represent on the affidavit of succession that you're not aware of any creditors, or if you are, that they're going to be paid.
Right.
But yeah, I mean, that is an issue. You do run that risk.
All right. Well, thank you, Sean, for the legal update. With that, we're going to turn to our topic for today, which is how bankruptcy impacts the sale of real estate. And so we're going to talk a little bit about bankruptcy. We haven't gotten a lot into that in our program, and we're looking forward to getting more into the weeds on what the federal courts say about the bankruptcy process. And with us today, we have attorney Leonard Sominsky, who has joined us and agreed to be here with us to talk to us about the process of bankruptcy and the impacts that it has on real estate. Leonard, thanks so much for being with us.
Thank you. Thank you for having me.
So, Leonard, give us and our listeners idea. Tell us where you're licensed and where your office is located.
Sure. Well, I'm licensed in Arizona. I'm kind of inactive in Missouri and Kansas, but I've been here in Arizona since essentially the year 2000. And we're here in Phoenix off of Indian School and 3rd Street, right downtown.
Tell us about your law practice. Is it just centered around bankruptcy? Do you do more?
We,
Or
we do we do quite a bit of bankruptcy, a little bit of estate planning as well, and just a smidge of real estate. But yeah, that's pretty much where we are.
now, how did you? And feel free to take us back on a long history lesson if you'd like. But how'd you get involved in bankruptcy? How did that kind of become your thing?
Well, like so many things in our profession, it just turned out to be the place that I got a job in.
Where you
When
worked for?
Right, exactly. Well, we moved here from Missouri and Kansas, where I was practicing essentially a lot of landlord and tenant law. Worked for a large, high volume filer, what they call. We did a lot of evictions. Um, and then when I came here, it's not something I really wanted to do, and the law was different a little bit, and just turned out got hired working for a small bankruptcy outfit, and kind of liked it because you're helping people. You're on the other end of it, instead of kicking people out and suing them later, you're actually helping people get a fresh start and eliminate their debts and get back on their feet.
Sure. So as you know, this podcast is really devoted to real estate investors, that process of dealing with real estate and real estate as their investment. And real estate law invokes a lot of different areas of the law, obviously contracts, real estate, liens, bankruptcy, and the list goes on and on.
Right.
So depending on where you are in the process might depend on where you sit. But what we wanted to do just to kind of begin with is give our listeners an idea about what bankruptcy is. Now, everybody's got this idea, big idea in their head about what they think it is. But
Sure.
from a lawyer that does it day to day and knows the process, what is kind of at a really foundational level bankruptcy?
Sure, sure. Well, bankruptcy is a federal law that allows somebody to file some paperwork with the bankruptcy court, and what it really does is eliminate certain debts, and basically it gets rid of your legal obligation to pay certain bills. Now, certain bills are politically incorrect to eliminate, like, for example, child support or criminal restitution or DUI fines. So even though those are bills you very well could be suffering from and cannot pay, the folks that drafted the rules decided that those bills, for the good of society, you get to keep the paying. But things like credit cards and medicals, evictions, repossessions, things of that nature, um, they're unsecured and they can be eliminated with bankruptcy. So it's basically a federal law that basically sits on top of all the state's laws, and anybody can choose to go to bankruptcy court, and if they're qualified, file a paperwork and get it reviewed. And if everything is sort of done correctly and properly, then these particular debts will be eliminated. So that's what bankruptcy is. It's a process to
Sure.
eliminate some debts, but like I said, not all debts will be eliminated.
So for a real estate investor who might find themselves, whether it's through a transaction being hauled into in dealing with bankruptcy, or whether they've decided to do it for themselves for whatever reason, give us a lay of the landscape. When you say a federal law, um, this is a court proceeding. Where jurisdictionally am I going to end up if this process takes over my transaction, or if I end up having to file?
Oh, absolutely. So the U.S. Bankruptcy Court for the District of Arizona is here in downtown Phoenix. It's one of the reasons why we're down here. And anybody who files a bankruptcy in Arizona will wind up in that court. Now there's several remote locations throughout the state for hearings and whatnot. So not everybody, like in Flagstaff, would wind up driving to Phoenix, but or in Tucson. And now, because of the pandemic thing, all of these are now done mostly remotely through Zoom and whatnot. But yeah, the physical courts, there's 3 locations throughout the state, and Phoenix is where it is here.
Gotcha. So my next question, I kind of want to group 2 questions into one. one, who can file bankruptcy? We've done a number of shows about structuring your real estate investments.
Right.
Oftentimes, these real estate investors are either contracting individually with each other or through entities. So is there any limitation on, one, who can file bankruptcy, whether we're talking about a company or an individual? And then two, if you would explain the process of the different chapters of bankruptcy. You know,
Yeah.
we've all watched enough court TV to know that there's different chapters of bankruptcy, and we might
Right.
throw them around to make ourselves sound smart. But if you could explain that process to us as well.
Sure. So those two questions kind of dovetail together because the nature, which kind of chapter you file, depends on who's filing. So by far, Chapter 7s are the kind of cases that are the most common. Probably 85% of the cases filed throughout the United States for bankruptcy are Chapter 7s, which are liquidations. And those can be filed by either individuals or legal entities. But usually for a legal entity like an LLC or a corp to file a 7, that's usually the end of the legal entity. So Chapter 7 is a liquidation. It's kind of like a winding up. So for an individual, when they file a Chapter 7, they're just wiping out their bills and getting a fresh start. And 4 or 5 months later, they're debt free, or at least certain kinds of debt free. Whereas for an LLC that files a Chapter 7, the trustee kind of comes in like a receiver and padlocks the place if it's like a building, and sells all the equipment and liquidates it and wipes out all the bills of the company. So those are 7s. They're the fastest and probably the most affordable to do. Chapter 13s are the next most common, and that can only be done by an individual. So LLCs can't do a 13, or just has to be a natural person. And it's a payment plan where you propose to pay back some of your bills. It's a 5-year thing. It could be as short as 3 years, but to lower the payments, it's typically 5. And it's kind of like a consolidation. It's a payment plan. You still eliminate a lot of your bills, but it's you pay as much as you can afford to pay. So it's kind of a sliding scale thing. And Chapter 11s are business reorganizations. So they're basically like a Chapter 13, but just for businesses. Now, it doesn't have to be a business. So an individual, a really high net worth individual, could file a Chapter 11 because and pay back some of their bills, because Chapter 13 has like limits. It's meant for relatively poor consumers. And they've recently upped those limits, but it's still limited. So if you have $50 million worth of liability and you don't want to wipe everything out, you're going to need to do a Chapter 11 if you're an individual, because you wouldn't be able to do a Chapter 13 because that's above the limits. There's another kind of bankruptcy. It's called a Chapter 12. It's for farmers. Never done one. But I believe it's a payment plan as well. And
are there farmers in Arizona? I think there might be a few.
There's probably plenty of farmers in Arizona. I know it's a big part of our economy, but yeah. I have never had the pleasure. Not even in Missouri and Kansas, where there's also a ton of farmers. And Chapter 9s for municipalities. Also never had the pleasure of doing that. But I think up in Detroit, there might be something going on up there. So those are the 4 basic types of bankruptcy available.
Leonard, thank you so much for being with us. We really appreciate it. So I wanted to jump in here and talk about the automatic stay, because that's always something that us attorneys kind of hear. Don't violate the automatic stay, you'll end up in federal prison, type of thing. Right. So what is it? And
So you're absolutely right. I mean, the automatic stay is basically bankruptcy's big claim to fame. So it's a federal court injunction that automatically kicks in as soon as the case is filed. So you don't have to do anything extra to get it. If you file the bankruptcy petition and you pay your fee, or even if you defer your fee, if you just procedurally meet the basic requirements, the bankruptcy court automatically gives you this. And basically all it says, it's an injunction that says nobody can be calling, harassing, suing, or garnishing you. And it stops any kind of, transactional activity. The theory is it basically puts a freeze on pretty much everything except maybe criminal activity. and says, okay, let's figure this out. Let's find out. Because the folks that are running into bankruptcy, they're usually being hounded by multiple collections activity, possibly lots of repossessions or lawsuits or evictions. So there's potentially a dozen creditors and competing interests going after their limited pot of money. So the bankruptcy idea was just, let's put it all on pause. Let's figure this out. So everybody just stop. So unless it's a criminal prosecution, which won't get stopped at all, or like child support, or any of the domestic support obligations, which also don't get stopped. I mean, there's other provisions that go through it, but basically just about everything else is stopped. You can obviously go and get it lifted, and that's when all the lift stay practice comes into play. But you basically have to go to the bankruptcy court, file some paperwork, and explain to the judge why you believe you're a creditor that should be treated differently, and the injunction should go away, and you should be allowed to proceed to, collect, and you have to explain why. So.
And does it apply to all chapters?
Yeah, the automatic stay, as far as I know, applies in every single bankruptcy right away. As soon as you file, it's automatic.
Yeah, it's automatic. So, and we've talked about this in the past. I mean, if you're a borrower and your property is up for auction and you file for bankruptcy 10 minutes before that gavel drops on the
I've
sale.
done it. Yeah.
That sale's no more. I mean, that sale was not supposed to happen, and they have to completely unwind the sale, right? Yeah.
Right. Obviously, it's not really good practice to wait that close, but we've certainly done it within 24 hours, or even the same day within a few hours. But the key idea in those situations is notice. You'd want to contact the trustee, the foreclosure trustee handling the sale, and provide him proof of filing of bankruptcy and the case number, and then. But it's the sale would be void if it's got through and they didn't know about it, and then you could whip it out later and say, but here it is, because they're date time stamped, and so timing is key. Yeah,
I mean, it could be a minute, before the actual sale. If the sale is scheduled at 10 a.m. and you file at 9:58 a.m., you're good to go probably to unwind that sale. Now, let's say hypothetically, and I actually have seen this play out, and maybe it's just, hey, too bad, so sad, but let's say hypothetically that no notice was given to the trustee, so the debtor files for bankruptcy, likely not represented by counsel, but they file, and 60 days after the trustee sale, and that the property's been sold to a third party, twice removed, for example, like, when you have a loan out there, a mortgage out there, the whole thing, how do you unwind something like that?
Yeah, well, from a bankruptcy perspective, we wouldn't, right? It would be somebody would hire an attorney to try to prove it. But I mean, you would think that if this third party buyer, unless they bought it for cash, there would be a title search. The bankruptcy would show up. It's on the credit report. It's on Pacer. So hopefully wouldn't get, unless everybody's just blind and not paying attention and just doing everything in cash, it would show up much, much quicker than 60 days, probably within.
Right. So it would be more of a title issue that would have to be dealt with in that case.
Absolutely.
So a couple of scenarios to deal with the automatic stay. Does it affect so let's say that a seller sells property on like a carryback financing. So now they're the lender, right?
Mm-hmm.
They're getting $1,000 a month on their carryback every month from the buyer. And a year and a half later, they're just not going to make it. They have other debt. They need the discharge. They go and file. Does the buyer who's making these loan payments, do they have to continue to make those payments? Or does the automatic stay do something to prohibit them from making the payments?
Right. So the automatic stay is for the benefit of the filer, right? For the benefit of the debtor. So you got to identify who, and it's supposed to prevent collection activity against the debtor. So making payments is not collection activity, right? So it totally. So if the seller, the person the the person doing the carryback,
Yeah.
if they file for bankruptcy, that note and deed are property of the bankruptcy estate. That income coming in from the buyer, that's going to be counted. So it depends, I guess, what kind of bankruptcy this person filed. If it's a Chapter 7, the trustee will own that stream of income potentially, and it's an executory contract, could be able to. They'll probably try to renegotiate with the buyer and maybe buy them out or something, or have them buy it out. It happens when people file and they have like a residual stream of income, like from insurance or something, and it could pay for years. And the trustee tries to buy that stream of income because it's no longer the debtor's; it belongs to the bankruptcy estate. So, yeah.
What if there's a purchase contract that's in place? It's 45 days old. They're getting ready to close in 30 days. And that's all it is a purchase contract. The seller files for bankruptcy. The buyer still wants to buy the property. What happens in that circumstance?
The buyer would need to negotiate with the trustee. That contract would be the filer would disclose that I have a contract to purchase whatever, and it's an executory contract, which can be canceled or affirmed, or it's up to the trustee. There's 60 days in which to do it, and it becomes property of the bankruptcy estate. And the trustee will we keep saying the trustee, and potentially maybe the audience doesn't know. So
right.
Pretty much in every bankruptcy, except in a Chapter 11, there's a third party. It's called the trustee. They are a Justice Department commissioned collections agent. They make money on, depending on the kind of bankruptcy, they make money on taking assets and administering them, which means selling them, and using some of that money to pay themselves or their lawyer or their accountant. And then some of the residual of that money goes to your credit card, the creditors, unsecured. So the trustee would be very interested because otherwise they make like $50 a case from the filing fee or some small amount like that. So when they see somebody who files for bankruptcy with this midair transaction that's kind of half complete, they start to drool because they could make tens, if not hundreds of thousands of dollars in this transaction. Some of these trustees, because their fees have to be disclosed like once a year because they're audited by the justice people. Some of those trustees make millions of dollars a year that they have to disclose as public record. So they're sharks, especially in Chapter 7. In Chapter 13, it's kind of interesting. In Chapter 13, the creditors are supposed to get paid at least as much as they would have gotten in a hypothetical 7. So the Chapter 13 trustee puts on their thinking cap and says, well, if they had filed a 7, how much would we have gotten if we'd have sold whatever this is? And then they make you pay the equivalent amount in payments in a Chapter 13. So 13 is always supposed to pay a little bit more, even if it's 1 penny more than a Chapter 7. So the trustee doesn't really go after as aggressively. They just kind of hold you feet to the fire and say, either you're going to pay this extra or we're going to kick you out of bankruptcy or convert you by force into a Chapter 7 where this thing will be liquidated by force. So it can be pretty ugly. So you got to think it through before you file when you have these assets and you're moving things around. That's for sure.
Leonard, one area that I've always thought was interesting in bankruptcy, and I'd love to hear kind of your explanation of this and description of how this happens in bankruptcy. But before bankruptcy, maybe I've got lots of creditors. Sometimes to keep them at bay, I prefer some creditors to other creditors. Maybe I pay off the creditor that's
right,
the squeaky wheel, right? Yeah, or my friends. Yeah, you pay off the whoever else. But I can, as a general rule, prefer one creditor over the other. That doesn't mean that there's not some sort of consequence or that I'm not going to get sued for that. But that can happen, and that often does happen. That's not the same in bankruptcy. And if you could explain that, and then also kind of explain for our listener what the avoidable preference period is and what that looks like leading up to bankruptcy.
Yeah, that's a really big hot topic there. So I remember again the Chapter 7 trustees, the sharks, and since that's the most commonly filed case, they're swimming in these waters and they make a lot of money on these preferential transfers and treatments. So basically, there's now, keep in mind, I'm usually there to defend the filer, and so this is usually the domain of the Chapter 7 trustee and their attorneys. They specialize in this area of the law, so there's probably a lot more to it.
Sure.
But there's several sections that are involved here. So one is within 90 days of filing the case, the bankruptcy court trustee has the power to undo this transaction. Okay. Now there's some factors that are involved. Okay. Now kind of wrote them out here because we'll usually run into all of them. So the payment has to have been made for the benefit of a creditor. It has to be for an existing debt. The debtor has to have been insolvent at the time the transaction occurred. And the creditor must be getting more than they would otherwise be getting without the bankruptcy. Okay. So if you meet all four and you're within this 90 days, the trustee will lawyer up and will intercede for sure. And they don't care. This is a third party. This is not your friend. This is not your relative. This is literally any kind of transaction that's not in the regular course and scope of your business. Okay. And there is litigation back and forth about whether you were insolvent at the time, whether this was part of your regular course and scope. And again, depends if you're just a consumer debtor, what's your course and scope? Just making your payments or just selling your house? So, I mean, if you're an investor and you're buying lots of properties, you might have a much broader scope of business. So that's the 90-day one. There's also the fraudulent transfers deal, which is 1 year look back, and that really focuses on insiders, which are friends, relatives, and business partners. And that one is even worse. Okay, so we're talking about the transfer actual fraud, which is a transfer made with intent to hinder or delay, and of course constructive fraud, which is the debtor just got less than fair market value, and the debtor was insolvent at the time of the transfer. So for the second prong of that, you have to be both insolvent, which you could fight about, and fair market value, which we have fought about a lot as well. So the trustees get into this Monday morning quarterbacking. I've had clients who, they sold some jewelry 6 months or 9 months before they filed for bankruptcy because they went to a pawn shop. The pawn shop, this is actually a real case. They went to a pawn shop. The pawn shop said, hey, we'll give you, $1,000 for this watch. And so the debtor goes, and instead of giving it to the pawn shop, she sells it to a relative. Okay. With a bill of sale, the money, everything. The trustee comes back and attacks it, saying, hey, I think even though the pawn shop said it's also $1,000, I think it's worth more. I've seen them on eBay for more, and I want the difference. So and they can dismiss the bankruptcy if you don't cooperate or win in court. So hopefully those are the two: 90 days and a year.
Don't get cute with your stuff right before filing bankruptcy.
Well, absolutely. Well, a lot of times people just don't know, right? A year is a long time. You might not know that within a year,
sure,
a catastrophe will befall you. And then all of your transactions from the last year will be scrutinized with a bankruptcy lens. But yeah, if it's a big transaction, you definitely should consider waiting for these things to time out. Yeah, that's big.
I know you do some real estate work, and you're active with some real estate groups in town.
Yes.
We met, I think, at a buy and hold meetup, which
That's
you
right.
know is about long-term holds on property and tenants and all that good stuff, or rentals. What happens to a property or in a situation where a tenant of residential property files for bankruptcy?
Yeah.
What's the landlord to do?
Right. So again, it kind of depends on where the landlord was in this scenario. Uh, so if you already have a judgment for possession and you just haven't kicked them out, the automatic stay will let you slide in and you could proceed with the irregular eviction with your forcible detainer. Or the execution at this point. But if you don't have your judgment for possession, then basically the automatic stay slams shut the case and just pauses it. And then you need to, as the landlord, run to the bankruptcy court and file your motion for relief. I've had multiple cases where the tenant just files a pro se Chapter 7 just to buy more time, just to get it. They wind up dismissing it for not filing documents. So it just gives them an extra 10 or 15 days of procedural delay. And the Justice Court or Superior Court just sits there twiddling their thumbs. So, but yeah, if they actually followed through and filed the proper documents to have a proper bankruptcy case, then you would want to file a motion for relief and get in front of the judge. And you can get it on an expedited basis. I mean, normally it takes like maybe 2 weeks, 3 weeks to get a hearing. But if you're a landlord, you don't want to wait that time. You can ask for an emergency hearing and get one within 2 or 3 days. And the judges are pretty understanding and will allow you to resume your. So they're not going to give you any more remedies than you would have gotten under state law. They're just going to lift the hold and allow you to go back to state court to finish your state court procedures, which could mean filing, giving your 5-day notice and filing your forcible detainer or whatever, and getting your hearing.
What if you're 6 months into a 1-year lease, tenant is paying as agreed, but tenant just files for bankruptcy because of other debt, credit cards or whatnot?
Yep.
And now you have this automatic stay. Can you, as the landlord, accept rental payments going forward, or do you need to go obtain special approval from the court to continue to accept rental payments from the tenant?
You should be able to get rental. I mean, you're not violating the stay. You're not collecting. The tenant has an obligation if they stay and accept the lease. They have an obligation to keep making payments on the rent. It's the rental payments are actually what's called an administrative expense, which gets extra priority. So once you accept the lease in the bankruptcy as the filer and the tenant, then you have an obligation. You're on the hook, basically. You basically are responsible for all of the rental payments while in bankruptcy if you accept the lease, and as long as you stay, you're required to pay. If not, the landlord can get the motion for relief filed and say, hey judge, they're not following the deal. We want to evict them and give us our state court remedies back. Let us go back to our forcible detainer. And so and it kind of depends on which kind of bankruptcy they're doing, a 7 or a 13, but the analysis is generally the same. If they make the payments, you should accept them, and because they're supposed to be making the payments if they're going to keep the property.
At what point does the tenant make the election to accept the lease?
60 days if it's residential, 120 days if it's commercial. Yeah.
Okay.
So yeah, they have to do that, or it's automatically presumed canceled if you don't affirmatively do that. So, yeah.
So basically, if you're a landlord, let's just say residential for now, we won't get into the commercial just yet.
Yeah.
But you're a residential landlord, your tenant files for bankruptcy. I'm assuming they'll send you a notice.
Right.
Tenant's current. As long as the tenant stays current, nothing more can be done. But at what point, let's say on the 50th day, the tenant decides to, or no, let's just say 61 days goes, and on the 61st day, there's not been an election to accept the lease. The lease is deemed canceled. What kind of notice does the landlord get in that scenario?
Well, I believe that section of the law basically says if you don't elect and it's canceled, then the stay doesn't apply anymore, and you could proceed. A lot of landlords, though, would probably try to get a comfort order and still file a motion for relief and say, hey, judge, they didn't elect it. it's presumed to be rejected. We want you to kind of double check to make sure, because you don't want to run afoul. Because if the tenant changes their mind later and says, "Oh no, you never lifted the stay and you evicted me wrongfully," there could be penalties and liability that way. So most landlords get a comfort order, to be sure.
Now, could this ever happen where the tenant does not accept the lease within 60 days, but they maybe want to stay in the property, so they continue to make their lease payments even after 60 days? The landlord accepts those payments.
Right.
What is the tenant on a month-to-month at that point, or is that
right? State law would apply, right? I mean,
okay.
If they're not breaking, if they're not breaking the lease, I mean, the landlord would have to affirmatively want them out. But yeah, I think state law would apply. And if you're accepting the rent, you're creating a month-to-month lease. So that's my 2 cents on that.
Right. So at that point, you can't just go into the bankruptcy court and say, "Hey, I want them out," or go into eviction court and say, "I want them out." If you've accepted the payments and they've not chosen to accept the lease, which means the 1 year or 2 year lease term is no more, but now they're month to month, then you have to give them the required statutory 30-day notice and all of that. But you could give them that notice without violating the stay at that point.
Right. Because you remember, Chapter 7 is only like 4.5 months long, after which it's done, and you're back to kind of like the filers got less debt, but you're free to continue to, the stay is over with when the discharge happens. And so there's no worry of violating the discharge. I'm sorry, the automatic stay. So at that point.
Now, does this analysis change at all in a Chapter 13?
Well, not really that much. I mean, if you stay in the property as a tenant, you're supposed to keep paying the rent, and obviously follow the other provisions of the lease with regard to, pets and trash and whatnot. And if the landlord sees that you're breaking the lease during the bankruptcy, I mean, 13 essentially is just a really slow motion Chapter 7, so it just goes on for 3 to 5 years. But if during that the stay is in place during that entire time in a 13, so if the tenant stops paying rent a year into it or something, you'd file a motion for relief as the landlord, saying, "Hey, they broke the deal," and get permission and go after them in state court, and just like normally, get your judgment and garnish their wages if they're working.
Now, in a Chapter 13, if they don't cancel within the 60 days and they up and move out, and it takes you a couple of months to rent the place and there's some damages and stuff like that, then essentially you become a creditor.
Yeah. Oh, absolutely.
Okay.
Yeah.
Okay.
Yeah.
Are you a creditor if they continue to pay and stay in the property, even if they don't accept the lease?
As a matter of, bankruptcy is all about notice. So you want to notify everybody on the planet you could conceivably owe money to, even if it's just a contingent potential possibility.
Right.
So yeah, I would definitely put the landlord in there. Even if you think you owe them zero, you'd say, "I owe the landlord zero, but I want them to have notice that I filed." This way they could, because the law doesn't apply really well if the landlord tries to evict you, if any creditor goes after you and you never notified them that you filed for bankruptcy, they have a really good argument for saying, "Well, I didn't know the stay was in place, and therefore I didn't violate any stay. I'm free to collect." There's litigation back and forth on this, but it's really much better practice to notify everybody on the planet.
And that's just not in bankruptcy. That's everywhere. I always tell our associates, more notice is better than less notice. Like, if you're going to default somebody, you give notice to everybody that you think you need to. Any attorney that could be out there that represents them, and every address you can think of or know of, and notices to release liens or obtain payoff statements. You just basically send it to every address and fax number and email you can find, because you generally aren't going to get in trouble by giving more notice. It's going to be the lack of notice that's always going to come back to bite you on anything.
Yeah, absolutely. And in bankruptcy court, it's the bankruptcy court itself that actually mails the notices out. So you just give the bankruptcy courts a list of names and addresses, and they send it's their postage. It's part of your filing fees. They pay for the postage. They do the printing. They do the mailing. So, yeah.
Well, I like that. I wish the Superior Court would do that for.
Yes, that'd be wonderful.
So Leonard, let's flip this on its head now.
Sure.
I'm the tenant and I'm paying rent, and we'll keep it residential here. And my landlord files bankruptcy.
Okay.
I guess at a baseline level, what should the tenant expect his or her obligations are going forward throughout this process?
Well, I'm not even sure if the tenant's got to pay rent and not violate the lease. So the lease stays in place. I mean, it's up to the landlord to accept the contract. And at some point, depending on the kind of bankruptcy the landlord filed, the trustee would get involved potentially. In some cases, the trustee would contact the tenant and say, hey, I own the lease now, essentially. I own this contract because it's property of the bankruptcy estate in a Chapter 7. And this rent that you're paying to the landlord, pay it to me. I'm now the executor, essentially, of this estate. In fact, I wanted to make this analogy before. Bankruptcy and probate are similar in concepts. There is, instead of a personal representative, there's a trustee, but there is an estate. Nobody died in bankruptcy, but your finances died. Okay, and so the trustee and the personal representative are very similar, except typically the trustee is much more aggressive because they're usually a third party, unlike a personal rep is usually a family member or a friend or something. So that's the end of the analogy. But yeah, the tenant is supposed to keep making payments on the rent, following the rules, and they could usually make a deal with the trustee, because a lot of times, as soon as the tenant figures this out, they probably want out, and they try to make it. They either stop paying the rent and wait for the trustee to do something about it, like an eviction, which the trustee might not want to spend their own money to do the eviction, so the tenant will just get a free ride for as far as they can get. So
along these same kind of lines, we talked a little bit before the landlord-tenant issue about sellers filing bankruptcy, but let's talk about a real estate contract where the buyer files for bankruptcy. What does that look like for purposes of the does that just really come down to, at that point, whether the contract has some sort of value to the trustee who now owns the assets?
Exactly. A lot of it, again, the kind of bankruptcy that was filed. So in a Chapter 7, the trustee would definitely own that contract, right? It's an executory contract. And I don't know what it's worth. Is it worth consummating? Can it still be consummated? If one of the parties is in bankruptcy, were they bringing any money to the table? In bankruptcy, you're disclosing all your assets and all your liabilities to the bankruptcy court. Are you able to proceed with the deal? And it has, and we're talking about, I guess the deal is kind of like stuck in midair. So this is, there's been no closing yet, right? Is that what?
Right. Yeah, right. No closing, stuck in midair. And I guess where we're going with this to some extent is, could you ever see a scenario? I don't know legally why you couldn't, but tell me if I'm wrong, where the trustee was a real estate investor in a past life, and he liked to assign contracts, or she liked to assign contracts.
Right.
And the market was one in which we saw maybe not that long ago where it's moving and there's value in being able to sign a deal. Could a trustee, in theory, if there was value in that asset, be able to do kind of a similar process?
They could sell it. I mean, this happens, like I said, with those residual things where it's a potentially very small stream of income that goes on for potentially years. The trustee doesn't want to get $50 or $100 here and there, so they'll go to those companies that will pay out a whole bunch of money, like instead of waiting, like with lotteries and stuff like that, instead of waiting for, they'll just give you like half of the money now. So there's there's companies out there like that. So yeah, the trustees are definitely connected with that. Some of them have their own little eBay sites where they will auction things off. So there's about a dozen Chapter 7 trustees here in Maricopa County and a couple in the other counties. But yeah, so they're aggressive, and they could definitely sell it or assign it. I've seen them threaten to do that with airline tickets, like tickets they can transfer. That you bought, you were going to go with your family to far away, and then they're worth $5 or $6 grand, and if they're transferable, they'll sell them. And I don't know if any creditors are going to make any money, but the trustee certainly will. So,
Leonard, one strategy in creative financing is what they call the sandwich lease option, which is you find somebody who wants to unload their property and is wanting to take payments over time. And so you say, okay, I'll lease your property for 5 years, pay you X amount of dollars per month, and then you give me an option to purchase in 5 years. And, maybe you pay $5 grand for that option. So you pay, some value. And, 2 years in, and of course the exit strategy for the initial, landlord slash optionee, not landlord, tenant slash optionee, is to then sublet and find somebody they sublet it to, and they give someone else an option that, trumps their option or is for a purchase price greater than their option. They take an option fee. Couple years in, original seller, or owner of the property for that matter, not really even a seller, owner of the property, landlord slash optionor, files for bankruptcy. So you're past the voidable preference. What would the trustee do, or could they do with that option, especially if it's like a 5-year option? I mean, it's like 3 years before something's going to happen. What would the trustee do? And could the property still be purchased with that option?
So the trustee steps into the shoes of the filer, of the debtor. Okay. So if the debtor could have done it, the trustee can do it. Okay. So to whatever extent, with your scenario, it's hard for me to imagine exactly this happening. I'm sure it happens. But this sandwich financing, but the contract itself, again, the trustee owns that, so they can cancel it if they think it's not favorable, or they can try to assign the contract, like we were discussing before. So again, they're a lot of times, though, it's just essentially extortion. They'll go to the party. The trustee will just go to the parties and say, okay, guys, we can do all these things to you. How much do you want to pay for us not to do them? Okay. And a lot of times these things just get worked out. Okay. Because if this was a really lucrative deal to somebody, they would rather pay, because, their life just got much, much more complicated. And this is stressful. These fees were not anticipated. And so a lot of people would just want to pay to make it go away, so they can continue on with whatever they were planning to do with the property. So yeah, these things usually get worked out with the trustee. And
now, is a trustee bound by like a non-assignment clause? So if the option states that the optionor cannot assign the option, is the trustee then bound by that if they are able to step in the optionor's shoes?
Yeah, I mean, the terms of the contracts do apply, but the trustee can go to the judge and say, for the benefit of everybody, and I represent all the creditors here, by the powers invested in me by the Justice Department, so this is all arguable. So they could ask for it to be remove the straitjacket, so to speak. They could ask for it to be liberated. for the benefit of the unsecured creditors. Because you remember, bankruptcy is sort of a bargain. You get to keep certain things, and you get to wipe out all these assets. All these liabilities. But a lot of times, if it looks like you were just too sneaky for your own good, there's an equity argument. And the trustee will say, hey, look, you're wiping out hundreds of thousands of dollars worth of bills. They should get something. And here's this prize. It's unequitable for you to kind of walk, so hopefully that makes sense.
Back when the market had a downturn, and both Andy and I did some foreclosure and short sale consultation work, and I can't even count the number of people that showed up in my office and said, okay, well, what loans are out there against the property? And they said, well, I only have a first position loan because I discharged my second in bankruptcy.
Mm-hmm.
And I, then had to inform them, well, did you obtain a release of the lien? Was the lien, removed through the bankruptcy proceeding, or did you just discharge the debt? Well, I don't know. I probably just discharged the debt. And then I informed them, well, the lien remains. Can you explain the difference between, discharging debt and actually removing or stripping a lien from?
Yeah. So getting rid of your if you're talking about the 2008 disaster, what you could do with a Chapter 13, and only in a Chapter 13, if you were upside down, you could strip off the second mortgage. But obviously, there was a lot of people were just walking away from their houses and letting them go into foreclosure, and then just doing a bankruptcy to wipe out any kind of residual liability. They probably wouldn't have anything on the first, but they would have liability on the second mortgage, and the Chapter 7 would wipe it out. But if you wanted to keep the house, the 13 would allow you, if you were upside down on the second mortgage, you could you could file a motion or an adversary proceeding in bankruptcy court and get rid of it. If you're talking about, well, if I didn't answer your question, was there more to your question?
Yeah, I think a lot of homeowners, even investors, don't really appreciate the difference between the debt and the lien. And what that means for bankruptcy purposes. You get rid of the debt, but the lien remains unless you do like what you did, a cram down or whatnot in a Chapter 13.
Right.
So let's just
Sure. Okay, so secured. So I think you're talking about really secured. This really comes into secured creditors. Okay, so but you could actually also get a lien now with a judgment against thanks to the legislature recently.
Right.
So this is how I like to explain it. So when you finance a car or house, your debt comes in two parts. There's the actual note, the loan, which basically this is where you promise to pay people back. And then there's the lien, a security interest that attaches in the collateral, the property itself, whether it's a car or a house. And although either bankruptcy, 7s or 13s, or any of them, will wipe out the note, they don't wipe out the security interest, the lien, if it's properly perfected, which if there's a deed and it's recorded, or if it's at the DMV with a lien holder, it's also properly recorded. So what that means is that for all practical purposes, the creditor, although they can't sue you for the money if you did the bankruptcy because the note's been destroyed, they can foreclose or repossess the collateral without violating the stay or the discharge injunction. So that's essentially the difference. Basically, secured creditors have two powers, both the note and the deed, or the lien. And an unsecured creditor just has one. They just have the contract. So your credit card creditor for a personal loan or whatever, that's just a note, which is completely dischargeable in bankruptcy. And there is no lien usually associated with that unless they take you to court and get a judgment, which now automatically attaches to any property you have. and you got to file a motion with the bankruptcy court to get rid of it. I think that's where you're going with that. So, yeah.
Have you seen that with the new law where people are
Not
going?
yet. I mean, it's just been around for 9 months, but yes,
Yeah.
a lot of people are saying it's coming. I haven't really, I mean, I filed thousands of cases. I haven't really seen it, but you think that sooner or later, some of my previous clients will come forward and saying, "Hey, I'm getting sued for this thing from 3 or 4 or 5 years ago." And yeah, we'll wind up reopening the bankruptcy case and filing the motion to kill it. Yeah, it'll be fun.
All right. Well, Leonard, we really appreciate your time being with us today. Tell our listeners how they can find and connect with you.
Sure. Well, office number would be 602-256-9800. And I can be reached by email at info@lvslaw.net.
Awesome. Well, thanks so much for all of your time, Leonard. We really appreciate it. If you have a bankruptcy issue, or a bankruptcy issue pertaining to real estate, anything along those lines, find Leonard. He'll help you through it. Again, thanks so much for joining us. With that,
Thank you, Leonard.
Thank you.
With that, make sure to join us next week. We're talking about divorce. Is divorce disrupting your real estate deal? Strategies on how to work through that process. Thanks so much. We'll see you guys next week.
Have a good day, everyone.